Hi, I'm Martine.
I'm Jerod.
And I'm Valerie.
And we are talking to you today from a rooftop in downtown Los Angeles. We're going to talk about domestic violence cases and what happens if the accuser or the alleged victim does not want to testify against the defendant at trial. And this is often a situation where it's the boyfriend, girlfriend, husband, wife of the defendant does not want to get on the stand, wants the case dropped, and doesn't want to testify against their loved one. So what's the first thing that this person should do?
Well, we always recommend that the complaining witness, when we say the complaining witness, it's the person who is the victim of the crime, to get their own lawyer. It cannot be the same lawyer that the accused has, because there'd be a real serious conflict of interest. They should get an independent lawyer to help advise them of the consequences, because in a way, they're basically going against what the prosecutor wants to do. The prosecutor wants them to take the stand and say exactly what they think happened, but in this scenario that we're talking about, the victim or the complaining witness doesn't want their boyfriend or husband to go to jail, and they want the case dropped, so they don't want to testify against them.
Sure. Now, what happens if a sheriff's deputy shows up at their house, or LAPD shows up at their house, or any police agency with a subpoena to testify against their loved one at trial? What should they do?
Well, I mean, admittedly, if in fact someone attempts to serve the complaining witness and the complaining witness is served, meaning that they actually get the subpoena, there's very little they can do, but they must comply with the subpoena. That is a court order requiring them to go to court. So it's not like you can really avoid that, as long as it's served on you.
That means that if they're served, they absolutely need to appear in court. And I guess this goes back to what you were saying, Martine. Showing up in court and whether or not they get on the stand is a matter for the alleged victim, the complaining witness, and their lawyer. The complaining witness and their lawyer need to talk about whether or not they're actually going to get on the stand and any legal issues surrounding that. It's much more complex than this video, but if they get a subpoena, we all agree they do need to go to court, absolutely.
And the subpoena has to be personally served. They can't be sent by fax. They can't get a phone call from the district attorney say, I'm subpoenaing you to go to court. That's not valid. When we say served, it is hand served by anyone really to the person and received by hand again by the complaining witness.
Absolutely. Now, can they proceed, meaning can the case go forward? Can there be a trial without the complaining witness testifying? Can that happen?
Absolutely. Yeah. I mean, even if the complaining witness, the alleged victim, isn't there, oftentimes if the specific scenario or event that gave a rise to the charges, there might be 911 calls. There might be statements that were made to the, say, EMTs, or if there was some sort of injury, those people, they could be called. There could be a variety of ways that the prosecutor gets evidence into the case.
And obviously photographs of injuries. I mean, if there's any injuries, you better believe that the police officers are going to take pictures of it. So even if the complaining witness doesn't want to testify, disappears, say flees the country, if there's a photograph...
Which we're not advising anybody to do.
No, absolutely not. But, for example, they could absolutely prove their case with photographs, with independent witnesses, and as Valerie said, phone call, certain statements like 911 calls, statements made to medical personnel. There's certain circumstances where these statements come into court even if the witness themselves are not there. And that could be enough to seal the deal for the prosecutor on that case.
So I guess the bottom line here is that if you don't want to testify against your loved one and you believe you are going to have to testify against your loved one, it is a very highly advisable to get your own attorney, different than the defendant's attorney, to advise you, because there's a lot of complex legal issues surrounding this.
Right. So all these circumstances, every case has its own set of circumstances, so please feel free to call Valerie, Jerod, or myself. We'll be happy to answer any questions you might have.